Okay. Hi, everyone. Thank you all for being here on this Tuesday, August the 11th. We are Russo Law Group, and we are back for another Facebook Live webinar. This presentation is tips on selling your home. My name is Ashley, Client Services Coordinator, and I'd like to introduce two of our attorneys, Joshua Burzak and Frank Bequicchio.
Hello.
Hello. Josh is an associate with Russo Law Group, focusing on the areas of estate and trust administration, probate, and real estate. He's been selected in back-to-back years, 2019 and 2020, as a Super Lawyers Rising Star, which recognizes outstanding lawyers who have attained a high degree of peer recognition and professional achievements. So big kudos to Josh. Also joining is Frank Bequicchio. He's a partner with Russo Law Group and lead planner in our Islandia office. He has over 25 years of estate planning experience, and I know he loves that when I share that number with everyone. Age him just a bit. Frank is a certified elder law attorney and a member of the invitation-only NALA Council of Advanced Practitioners. Now, before I hand it over, I have two housekeeping announcements. This is a live webinar, which means we are available to answer your questions. And yes, we do encourage your participation. So please send us your questions and comments by using the questions box provided on the Zoom toolbar located at the bottom of your screen. If you're joining us through Facebook, feel free to drop your question using the comments section. Also, a survey will open in your web browser after you leave the webinar. Please let us know your thoughts about our program. All right, thanks for your attention. I will now turn it over to our presenters.
Thanks so much, Ashley. And one other thing in terms of the questions, if you don't get a chance, or as I often do, you hang up the phone and you think of a question immediately after, please feel free to contact us. You'll see our information at the end of the slide presentation today. So if you have any questions that you weren't able to ask today, or if we didn't get to them for some reason, please don't hesitate to reach out to us. So again, thank you all for listening in today. Josh and I really appreciate you taking out a little bit of time to listen to us. We'll listen to Josh mostly. I think he's going to do most of the talking. I'm just going to try to move things along. So what we're going to cover today, just kind of an overview. What should you do before you put up that for sale sign when you're looking to sell your home? How can you avoid the sale from falling apart? Josh will talk about some title issues and some other things, some pitfalls to look out for and maybe be more prepared for if you're looking to sell a piece of property. And what's our role as the attorneys in real estate transactions? As Ashley mentioned, Josh handles the lion's share of the real estate transactions in our office. So he's the guy to be handling this presentation today, because he's pretty much seen or heard most of everything to think of when it comes to buying and selling real estate. Okay. So Josh, you want to talk a little bit about the first step, which is maybe getting the house ready for sale?
Yeah. So obviously everything is about appeal and making the house presentable to the potential buyers such that they want to put in an offer. So it's important to declutter the inside of the property, to clean it and stage it, not only for photos to be posted, but also for showings, because you want it to be something that the average buyer will come in and want to desire to purchase. Curb appeal is also extremely important, because a lot of people look at the outside of the house, they do drive-bys. You can always power wash the house if there's a little bit of exterior uncleanliness. You can make sure that the the landscaping is done nicely, and always listen to your broker. Your broker has experience as to what needs to be done to prepare the house for sale. They'll ordinarily take a look through it and then give you their opinion of whether there needs to be any improvements that need to be made that would get you a higher price on the market. If there's anything that is wrong with the house that could really cause an issue with obtaining offers from buyers. So it's always important to inquire into your as what your broker thinks needs to be done.
Yeah, I guess, I mean, that's part of what they're getting paid for, right? Is to help facilitate that sale and get you the top dollar.
Yeah, you want to make them earn their money.
Yeah. So I guess the question is, you know, do you even need a broker? Or should you have a broker, I guess, is another question. Does everybody have to have a broker?
So everybody doesn't have to have a broker, but having a broker does provide some advantages. Most of all is the ability to list the property on something like MLS-LI or MLS, which is a listing service that brokers use. They do have connections ordinarily within the industry where they can get potential buyers or other agents to have their buyers show the house. That said, it's not a requirement. You don't have to have a broker. I've represented sellers or buyers who have been unrepresented. So it's not a requirement. But like I said, there are advantages. If you don't have a broker, there's really nobody advising you as to the market at the time, whether the asking price of the house or whether your listing price is far more than what the market is determining. They will be able to give you advice as to what to look at when you are, looking at the house and determining whether you want to buy it. So I would always recommend having a broker unless you are sure that you can handle the responsibilities that come with not having someone who they can handle those responsibilities for you.
Yeah, I think 100% agree. I mean, it can be a case by case basis. Like, sometimes we'll talk to people who, for example, maybe someone in the family, like a parent or somebody passed away, and, neighbors are already asking about, is the house going to be for sale, and maybe even making offers. And, maybe you're in a situation where you don't need a broker because you've got people already are looking at the house and making offers on the house. But I think in the more traditional or likely scenario is that you're going to have brokers who, as Josh said, can get it out on something like MLS, which will exponentially expand the number of people who are going to be able to see that the house is for sale. And then the price too, it's the house is worth what somebody's willing to pay for it, but sometimes you don't have any idea what that is, depending on, the neighborhood, the town, whether or not you're from the area, maybe you have some knowledge of it or don't. Interviewing brokers is another thing. I mean, we work with a number of brokers, and certainly can give input in terms of how we feel they work with our clients, and whether or not they'd be a good fit. So it's going to be a personal decision.
And to add on that, you always do your research, even if you have a broker. A quick search on the internet to see what comparative houses have sold around you can always be helpful. Even with the interviewing process with the broker to, get an idea of whether they are, hitting the mark as to what the value of the property is.
Right. Right. If the broker listed for a certain price and you don't get any phone calls or showings within the first 2 or 3 weeks, you're probably overpriced, right?
Yeah.
All right.
To drop it.
Next slide. Okay. All right. So when we were talking about this presentation, Ashley, Josh, and I, we thought that it would be good to talk about some of the issues that we, and specifically Josh, has seen where deals actually fall apart, where you have, you could be pre-contract, you could actually be in contract, and sometimes, God forbid, even to a point where you're getting to a closing, and now, you've got these issues, and we've listed some of them there, and Josh will cover a couple of them a little bit more detail, where a sale can actually fall apart and you lose the buyer.
So I would say common title issues, and I think they're outlined fairly well here because these are the ones that I deal mostly with and have seen the most during my career. Open permits. So with respect to improvements or additions made to the house, depending on the town that you are in, the town code requires you to open a permit with the buildings department before you move forward with the additions or the improvements, depending on what they are. And the permits are open through the town buildings department. Once the addition or improvement is made, you have to go through an inspection process to close the permit and have what's called a certificate of compliance or completion issued so that it's on file with the town that the additional improvement that was done was up to code and was done correctly and inspected.
So Josh, this is something that somebody can do on their own, right? They can go to their town hall, for example, and ask about open permits on their property before they even list it for sale.
Yeah, I know before COVID, you could just walk in to the town buildings department and you can search the file. Now there's, depending on the town, they're trying to limit foot traffic. You can always give the town buildings department a call ahead of time to see what their current process is. There may be a small fee. I know Town of Huntington actually puts theirs online. You can actually search online. You don't actually have to go down there. But it's always good to take a look and see if there's any open permits on file. It becomes a big issue when the buyer has a bank that they're getting a mortgage from, and then when a title company issues a title report and it runs a search of the town's building department of your property and shows open permits, the mortgage, the lender will want those permits closed before they agree to fund the loan. So it's important to get ahead of it because I've been in situations where the seller was unaware that there were open permits. In one instance, I had a client in Long Beach who did post-Hurricane Sandy renovations and repairs to her house that were required. She hired a contractor. The contractor opened permits, but he never closed them properly. And then we entered into contract and it became an entire issue once the title report was issued. And my client became aware that all these permits that this contractor opened to make the renovations and improvements and repairs were not closed. And we ended up having to hold money back after closing to make sure that the permits were closed properly. So that's a big issue.
Yeah, and that could take months, right? I mean, it could, depending on the town, that could take months for them to, if they have to do an inspection and if there are any issues with the inspection.
Yeah, it's all depending on the workload of the town, if they can get an inspector out there. Depending on how old the permit is, you may have to resubmit documentation. That happened before with regards to, and I've had a contractor who retired since then, and we had to get a new contractor to do all the paperwork. So it's definitely something that can easily be recognized before you enter into contract. And like I said, before the current setting, you were able to just walk in. I would suggest if you can't, or just giving a call ahead of time because they are staffed now and seeing what your options are with obtaining the information. Boundary issues is another huge one that I see very often. So in New York State, if someone is encroaching on your property, whether it's with shrubbery or their fencing, which is the most often one I see, over a foot from the recorded boundary line, you are in a situation what's called out of possession. And a purchaser's title company will not insure title to the property unless you are able to resolve that out of possession issue. So just to be aware, if your neighbor is putting up new fencing, or you yourself, or you may want to inquire into the services of a surveyor to make sure that they're done correctly. And the variable between the actual fencing position and the boundary line is de minimis. Now, if you have these issues, it can be rectified after contract, but you have to have cooperation with your neighbors. So a title company will be willing to issue title if the neighbors are willing to sign what's called an out of possession affidavit, stating that they acknowledge that they don't have any right to the part of land that they built on top of your land. Or if you sign a boundary agreement, which I've done before, where the parties come to an agreement how the piece of land will be used, that has to be recorded actually with the deed. But I've run into situations, for instance, where I've had a client who was selling his parents' house, and they had out of possession issues on all 3 sides of the backyard. And we had to go to each neighbor and ask them out of the kindness of their heart to sign an affidavit, acknowledging that they weren't really in possession of the property. They didn't own it. And this is actually where a broker was very handy, because the broker himself did it, going to the neighbors, because the son lived out of state and he hadn't lived there for long. He wasn't really familiar with the neighbors and were comfortable coming into New York to talk to them. And we actually ran into an issue with one of the neighbors who was refusing to sign, and my client actually had to, in order to avoid a litigation issue with them, had to compensate them and pay them to a part of their sale proceeds in order to sign the affidavit. So it's something that you definitely should be aware of, because it could create issues, especially if neighbors aren't cooperating. Open mortgages is another item that I've seen a lot of. This is more so for older mortgages where you've had a mortgage on the property, you've satisfied it, and then the bank ordinarily will send what's called a satisfaction of mortgage to the county clerk's office to have it recorded. And that way it's acknowledged and on record that you've satisfied the mortgage. Some banks have in the past mailed the satisfactions of mortgages to the borrower and did not record them directly. And then I've run into situations where we entered the contract, the buyer the seller believes that they've satisfied the mortgage, or that they have, and that everything's fine. And then the title report comes back. The title company runs a search on the county clerk's office to see past deeds and to see if there's any outstanding mortgages on the property. And then the mortgage is still sitting there despite being paid off some 20, 15 years ago. And then it becomes an issue of, does the seller have the original satisfaction of mortgage? And if they do, then we can just mail it and record it with the county clerk's office, or have the title company at closing do it for you. You'll have to pay the recording fee, but it's important that satisfaction is recorded. Or in the case where we can't find the mortgage, or we only have a photocopy because the borrower either threw it out or lost it, then we have to get into contact with the bank and have them reissue a satisfaction and record that one. So
and then heaven forbid the bank has changed, or the mortgage changed hands between banks, right? Because you've had those experiences.
I've had those experiences where
the bank doesn't even exist anymore.
Dime Savings Bank of New York is a repeat offender of this, in my experience. They would mail the satisfaction of the mortgage to the client, not advise them to record it, or they would advise them, but the individual didn't read the cover letter or didn't understand it and just thought, hey, I have my satisfaction, that's great. Dime Savings Bank, meanwhile, has gone out of business. They were bought out by Washington Mutual, and then they were later bought, Washington Mutual went under and later bought out by Chase. And now you're dealing with Chase Lien Release Services, and they've acknowledged that they do not quite have all of Dime Savings Bank's financial records from the past because of the change in hands. So it becomes an issue. And we've resolved them, thankfully, but it takes a lot of work, and you have to really work with the bank to get the mortgage reissued.
And the whole idea here, obviously, is to be proactive with these things, because you don't want to be at the 11th hour, in some of the examples Josh has given, where the title report has come in. And if the title report comes in, that means you're already in contract, the buyer's already applying for a mortgage, and now we're dealing with these issues that could take weeks or months to resolve, and hopefully get resolved, of course, in which case you run a high risk of losing your potential buyer.
Yeah, and of course you can always run a search on the city and Nassau County are fairly user friendly. They have websites that you can search the county clerk's office records. The city, I believe it goes as far back as you'll be required. Nassau, I think, goes back to 1993. I have to recheck. Suffolk is fairly well as well. Goes back well as far as well, but it's not user friendly. You really need to know the district, section, block, and lot, and you have to use the exact amount of how it appears on your tax bill to make the searches. They don't really allow you to search by name or property address like the other, like the city and Nassau does. So you could always do a search and just search to see if maybe, that mortgage you satisfied is still on record, and it may be a case of you having to just record it or advising your attorney to have it recorded at closing with the title company so that it's taken care of. Quickly, judgments, if you have a judgment in your name, it's going to show up, and the title company will most likely want you to pay it off prior to closing. That said, the title report, my clients sometimes freak out because they see that they have all these judgments. The title company will run your name, not your social security number. So if there's another Frank Bequicchio out there,
Believe it or not, there are plenty.
who maybe has less than 25 years of experience practicing law, then it's just a simple signing of an affidavit acknowledging that that's not you. So judgments, just to be aware, if you have judgments against you, this could be a something you need to take care of or resolve prior to closing, or and then just homes and trusts, just to be prepared, you want to make sure that the trust document, the trust agreement, authorizes the trustee to sell the property, that you have the required consents if necessary to sell the property, and that the agreement authorizes the sale. So you just want to maybe double check the trust agreement, the copy that you have, or just call your attorney to go over it to make sure that you have this right to sell the property at this stage. You also want to be conscious that if you're selling a property from a trust, the proceeds, the checks that will be cut at closing for the sale proceeds will be made payable to the trust. So you want to have a trust account, whether it's a brokerage account with a cash component or just a regular checking or savings account, opened in the name of the trust so that you can readily deposit those checks after closing. I know it's not on here, but also an important thing to recognize is life estates. If there's a life estate holder on the property, then if the life estate holder is still alive, you also have to have them sign off on all the closing documents. So they need to be cooperating and in unison with you. And then if they are no longer alive and you're selling the property, you just have to provide proof of death, like a copy of a death certificate of the title company, just to show that the life estate has extinguished.
I'm back. I don't know if you even realized I was gone. I lost my internet connection, sorry.
No problem. Next slide. Oh, sorry. Okay. So what is our role in the sale of the house? So once you have a accepted offer, whether you're the seller or the buyer, if you have a broker, the broker will write up the terms, the general terms of the sale on what's called a deal sheet, and will distribute that deal sheet to the attorneys for the buyer and the seller. If you're not represented by a broker, then it's simply getting in contact with your attorney, advising them that this is what you agreed upon with regards to general terms. And customarily, then the seller's attorney will prepare the contract of sale. They will then transmit that document to the purchase attorney for review, and the purchase attorney will ordinarily review it, make any comments or changes that they believe are necessary to protect their client's interests. And then there will, of course, be just a negotiation of the terms. Ordinarily, the attorneys will attach what's called a rider, which is a document that they themselves draft up with terms that they believe will protect their clients. If there's a home inspection that was done on the property, and there's certain issues that need to be resolved before, or repairs that need to be made, those would probably be in the rider, because the contract of sale is ordinarily just a standard form issued by the New York State Bar Association, that just has general boilerplate language with a couple of differences depending on the deal. Once the negotiations are completed and the terms are agreed upon, the contracts will be distributed for signature, and the buyer will ordinarily have to pay what's called a contract down payment that the seller's attorney will hold in escrow until closing for the interim of the deal. Once the contracts are signed, then the purchaser gets, and I've been saying it repeatedly, and I'll explain it now, will obtain the services of a title company, a title insurance company, to issue a title report, because they will want to obtain title insurance to make sure that the seller has the right to sell them the property. So the title company will do necessary legwork and research to make sure that the chain of title is good, that they received the, when the seller purchased the property originally, they purchased it from the correct person who had the rights to that property. And then they'll obviously issue all the, do runs of searches of the town's building department. They'll do judgment searches, Patriot Act searches, bankruptcy searches. They'll do a whole load of searches, a tax search to make sure that the property taxes are, if they're open or paid, or if they're there's any penalties levied against them because they're past due. The title report will be issued, and then the attorney's job is to review the title report and clear any title issues with the title company. Whether it's via drafting affidavits to be signed at closing, whether in the instance of, if we're selling it from a state, we have to provide them with a copy of the letters testamentary or the letters of administration from the court to show that the individual selling the property has the right to do so. For instance, I spoke about a life estate. If the life estate holders passed, they would want to see a copy of the death certificate to make sure that the life estate is extinguished, so that you're not intruding on their right to live in the property during their lifetime. So we review it, and then if there's any issues that we need to provide to our clients, we'll advise them of the issues. Now, once all title issues are cleared, we arrange for and represent the seller at closing or the buyer at closing. We'll prepare what's called adjustments. So if there's property taxes that paid within the closing period, there's always adjustments made so that if the seller has paid the property taxes, they're reimbursed at closing for the portion of the taxes that they're no longer in possession of the house by the purchaser. Similarly, if the taxes aren't due yet, but they're due to be paid and the purchaser is going to pay them, and you're closing within a tax period, the seller will provide them an adjustment, the purchaser an adjustment, to compensate them for that period of time in the tax period that they weren't in possession of the property. So the attorneys will calculate the adjustments, will negotiate them to a degree, and we'll make sure that everything's good. The seller's attorney usually drafts the majority of the closing documents and will provide them at closing, and then the attorneys represent you at closing in your presence, unless you're using a power of attorney, and we'll review the documents with you, make sure that you understand what you're signing, go through the numbers with you, and just make sure that there's no questions at the closing table. Another issue that is important for an attorney's role is if there's post-closing matters, such as post-closing occupancy agreements, or escrow agreements. So post-closing occupancy agreements, for instance, if you're selling a house and then you're buying another one, but you either need time to move out, and you're going to need more time than what the closing date's allotting you, or if you maybe you're closing on the purchase after you're closing on the sale and you need a couple days where you'll have no house to call your own, you can negotiate a post-closing occupancy agreement where you may be able to stay in the house for 5 to 7 days, and then you'll have to hold money back from your sale as sort of collateral to make sure you're not damaging the property in the interim. But that's something that the attorney can negotiate and prepare for you. Similarly, that ties in with escrows, because the money would be held in escrow by the seller's attorney ordinarily, or the purchase attorney, depending on how they want to go with it. But the escrow is a component of it. There's also other escrow agreements. I know I spoke about there was open permits that needed to be closed, and we actually did the closing with the permits opened, but we did have a post-closing escrow agreement where money was held to make sure that the seller was going to close the permits and not just leave the buyer hanging after they closed on the sale. So those are really negotiated in advance, the closing by the buyer and seller's attorney. And it just makes sure that whether you're the seller or the buyer, you're protected if there's any post-closing matters that need to be addressed.
I think that was great. One other thing I think that's important, especially for our practice and the real estate that we do, is making sure that the proceeds are properly paid out. So what I mean by that is if you've got what I'll call an atypical situation, which is the house, I know Josh mentioned, I think while I was offline, about life estates. So when there's a life estate and the person who has the life estate, or people who have the life estate, are still alive, there actually is a division of the proceeds that's supposed to happen at the closing based upon the ages of those people. There's a certain percentage that we have to figure out that they're entitled to. And the other is when the property's in a trust. I've had situations where I've set up a trust for a client, we put their house into a trust, and I'm meeting with them, potentially years later. One comes to mind because it was fairly recently, and they told me that they sold the house, but when they sold the house, the parents got all the money instead of the money going into the trust, which it was supposed to do. And they went to an attorney who wasn't familiar with trusts, and it happened, and unfortunately there was nothing we could do about it at that point. So I think it's important from an attorney standpoint that when you've got maybe an unusual situation, or not your typical plain vanilla situation, that we get involved so that all of these things are properly handled. Excuse me. Okay, I think we're up to Q&A time. Okay, so I don't, Ashley, if you've got, we're going to go back and see each other. Nice. I've got a chat here. I'm going to, I don't know if you guys can see it, but the question is, and I'm going to respond to it. We'd like to sell our house as is. What does this mean from a legal perspective? So I mean, Josh, it's basically meaning you're not going to make any repairs if there are any, title issues or CO issues. I mean, depending on how far you want to take the as is, right? That's going to be built into the contract.
Yeah, the generally as is means that it's take it as you see it.
Right.
There's going to be no further improvements made to the property. Like Frank said, you can go even further. If you're not dealing with a buyer who's obtaining a mortgage, if there's open permits or a CO issue, maybe you're dealing with a contractor or a developer. As is can also go as far as that they're going to take it with any open permits or CO issues.
But that's most likely almost certainly going to be an all cash buyer, right? I mean,
it would only be an all cash buyer, because the bank, once they see open permits or a deficient CO, they're not going to fund the loan without that being rectified. Right. So that's the benefit of having an all cash buyer, because it's a little less oversight, and you have more room to negotiate if there's issues with the house. But as is generally is take it as it is. That said, usually that doesn't apply to, it's essentially, this is what the condition of the property is today, and that's what you're taking it as.
Right, take it or leave it.
Yeah.
All right, so we have another one here. My husband just passed away in April. I'm sorry to the listener. We own our co-op apartment as joint tenants with right of survivorship. Do I have to have a deed modification, name change before I can sell the apartment? So the answer there is, if it's a co-op, you actually own a stock certificate, excuse me, and not a deed. And if you owned it as joint with right of survivorship, then when your husband passed away, it became yours automatically. So the answer to your question should be, I always say should be when you're dealing with co-ops, because you never know if they're going to want any additional documentation. But the answer should be no. You should be fine. If you were going to sell the apartment, you would just sell it as the surviving joint tenant. You would have to provide a copy of your husband's, or a certified copy potentially, of your husband's death certificate at or before the closing. Maybe a couple other affidavits that have to be signed, but it should be fairly straightforward, I think. Right, Josh? Anything to add to that one?
Not really. Maybe you might just want to call the management company or the co-op board and just double check. But ordinarily, if you're having it as joint tenants with rights of survivorship, it implies that once the the other joint tenant passes away, you as surviving tenant have full right to the stock. So
And that does hold true for deeds as well. We might as well throw that out there, right? So
yes.
if you own property, you know, a condo or real estate that is either joint with right of survivorship, or if you own it as spouses, which is a form of joint right with right of survivorship, it's the same end result. You don't have to make any change necessarily to the deed. If one passes, the surviving person can sell it without having to do anything additionally.
Yeah, usually it'll just be an additional blurb in the deed when you're selling the property, just stating like as surviving tenant of whoever the deceased joint tenant is, and just citing their date of passing. But there's no real need to do another deed, especially with the recording fees in Nassau County, particularly.
All right, so I got another one here. This one is for you, Josh. And it's interesting because it says the time is 6:39 a.m. So I wonder if the person is somewhere in the Pacific Ocean listening to this. Maybe in Hawaii. I don't know what the time difference is. All right, so the question is, and one you may not be able to answer, but I think you can based upon your experience. What's the average fee for the broker and seller's attorney on a routine closing without problems? Is it based on a percentage for the broker and hourly for the attorney?
Okay, so for brokers, at least in the state of New York, right now you're seeing an average of a 4% to 6% based upon the sales price as to their fee. And if you have a selling broker and a listing broker, so you have a broker for the buyer and you have a broker for the seller, they'll ordinarily split that depending on what they come to agree as to how it'll be split. So for instance, if you have a 6% brokerage fee, sometimes the broker will take 4%, the other one will take 2%, or they'll split it evenly. But from what I've seen, 4 to 6% is the market right now for brokerage fees. With regards to attorneys' fees, it varies. Some attorneys will do hourly, not a lot with real estate, just because the market dictates that mostly you don't do that. There are flat fees. And then there are capped fees where, which is essentially flat fee. But right now I would say the average is $2,000, $2,500 for a obtaining attorney. If you can obtain one for less than that, God bless them.
Yeah, be careful. All right. I don't see any others unless Ashley does. If maybe you can.
I see one more.
Okay.
I have a question. At what point do you usually engage the title company? So usually the title company is not engaged. First of all, it's engaged by the purchaser, not the seller. And the purchaser ordinarily engages it once the contracts have been signed and they're officially in contract. Usually the attorney will have a title company that they work closely with. We have one that we work very closely with that we use in any deal, and they're phenomenal. And that's when you usually engage them. You could maybe engage them ahead of time if maybe you want to run some searches on the property like we discussed.
Right.
They can do that for you, and if you end up entering into contract, they'll incorporate it into your usually they'll incorporate it into your closing costs that you would have paid if you just engaged them after, because it's searches that they would have had to run anyway in order to ensure title. So I would say ordinarily you engage them after signing of the contract, but if you want to do some preliminary legwork, you can always ask your attorney if they want to maybe get the title company to do some work before you enter the contract. But the risk there is if you don't end up getting your offer accepted, you will be on the hook to pay the title company a couple $100s for doing their services.
But it could be worth it, right? I mean, you've seen some of these horrors where they're open permits or old mortgages, and it might not be bad to even lay out a couple $100s for a title company to do a couple of these searches beforehand, just so you know what you're in for and you can be prepared and get your documentation in order.
Absolutely. I mean, I've had one where the certificate of occupancy and a bunch of certificate of completions for some reason were not on file with the court, with the county clerk's office. Yeah. And we didn't realize until we entered into contract, and or rather, a client didn't. And once we got the title company involved and they did a search, we would have known this ahead of time. And luckily, we were able to find the originals in the deceased homeowner's belongings and file them with the county, which was a godsend. But it's definitely something that's worth it in those situations.
Okay. So just a minute or so about Russo Law Group and what makes us different. You can see a couple of bullet points there on the screen. We've got a couple of locations throughout Long Island. Excuse me. So we pretty much have the island covered, which is convenient for our clients. Licensed in multiple states, in particular, including Florida, which, obviously we do a lot of elder law and estate planning, and that becomes important. We're strong in crisis situations, so not just on the planning side, but as Josh pointed out to you today, on the real estate side as well. Where we've got these title issues to deal with. We've got a lot of experience getting that done for our clients. Excuse me. And we've got another program coming up. I'm not sure. I don't know the date offhand. Ashley may. I think it's about a week and a half or so. The tax planning series with Vincent Russo. So I think that's going to be a good one.
Yeah, that's next Tuesday, August the 18th. Vincent Russo will be presenting on New York State estate tax planning.
Oh, wow.
I sent a link through the chat box for those of you on Zoom. So if you want to join us, you can go ahead and register now.
Great.
Thanks.
Thanks, Ashley. Okay, I think that would wrap us up for today. I want to thank Ashley and Josh in particular for Ashley putting this together and Josh presenting so well with all of his great insight. Thank you all for listening to us for a couple of minutes. And again, if you have any further questions after the presentation's over, don't hesitate to give Josh or me or Ashley a call, email, whatever it is. We appreciate it. Hope everyone has a great day and stays well.
Thanks, everyone. Bye.
Have a great day.